those kind of situations, they say, okay, let's combine it now. So one, private equity, second is startups. The third is sectoral consolidation, as I see it as the third big trend in 2017 and 2018. Why do I say that? Because there has been significant disruption in several sectors. I spoke about real estate. Now I don't know whether the real estate community has the mindset for consolidation, but as they say, necessity is the mother of invention. You may not like it, but you will have to do it. That's number one. Number two, look at sectors like telecom. Okay? Yesterday night, I don't know how many of you saw on television, there was a statement by Sunil Bharti. He said, I will not be surprised if by this time today, next year, you will have only 4 players in the telecom sector. Because the reality of life is this. The Reliance Group has deep pockets, and the reality is Jio has disrupted the telecom sector beyond our recognition. You will have to have consolidation. Now, who will merge with whom? Will there be a cultural fit? Will that merger succeed? I don't know. But the possibility that this could happen is a very strong possibility. So this is one sector. Look at another sector, cement. You today have the big daddy of all in cement so far as India is concerned, which is UltraTech. I don't know how many of you know, the UltraTech capacity is 95 million tons, which is more than 1.5 times the combined capacity of ACC and Ambuja put together. Both of which, remember, are wholesale group companies. So they are backed with a Swiss giant with massive pockets and which now has Lafarge within its fold. In spite of that, and by the way, because Lafarge had to be divested because of CCI and as you know, Nirma about it. So, but even had Lafarge been included, it was 72 million tons, because Lafarge was 12. But anyway, Lafarge is not there as a part of the whole thing now, at least so far as India is concerned. But if you look at this 95 million and you look at 60 million, there are other 2 million, 3 million, 5 million. How will they get the economy outside? How will the logistics and transportation cost pan out? They will not. Okay, so how will the branding get done? How will they get mind space in the mind of the customer and so on and so forth? If you keep all this in mind, this is another sector by concern. So startup, telecom, real estate, cement. There are many other sectors. Look at Indigo, aviation. So you have this flights into by 75% stake in Air Pegasus. Okay, today Indigo, Jet are of course relatively the big daddies, but you do have SpiceJet, you do have GoAir. But if the oil price, for example, goes from $60 to $90, then that possibility can happen in 2 years' time. And you anyway have lots of inefficiencies in India. It means you need consolidation and scale to survive. You will have that. Pharma is another sector where we see a lot of cross-border activities. I think the bottom line is a significant amount of activity because of various factors, scale, global factors, consolidation, etc. are going to happen. The other, of course, in India is distribution. The distribution is a very, very big factor. And global majors will find it very difficult to survive in India with their products unless they buy into a company with a distribution network. I remember many years ago, we deal with Colgate, and the global worldwide CFO of Colgate was there, and we were going in a car. It was his first visit to India. It was 7-8 years ago, and he could not imagine how that Colgate toothpaste has wound up with the Panwala. He says, why? He says, Ketan, how is my toothpaste showing up here? I mean, which channel does it go to? I said, I don't know, it shows up here for sure. So I think they need distribution network because India is, it's a different planet, right? You need distribution network, especially for FMCG products. And I think that will lead to another consolidation trigger, both from an India standpoint and otherwise. While Amrish, Bhavesh, Girish Mandari's colleague, and Sanjay Kuch will all go into the technical issues, and the idea is not to make this session into a technical one. But I just thought it would be a good idea to share some broad thoughts. I would call them random musings to sort of whet your appetite for the wonderful sessions to follow. So let me start with, let's say, schemes of arrangement. Okay, 3 or 4 points that I thought would be interesting In the recent decision in Edelweiss stockbroking, a prospective appointed date was permitted in operation. You and I have dealt with the situation of prospective appointed date in the past. An interesting decision, HCL Unit Packard, the appointed date prior to the date of incorporation was accepted. So, appointed date for a merger prior to the date of incorporation, because they said this is only for the purpose of calculation. The actual company may have come into effect subsequently appointed date. I did not get time to do the full decision. So, these are the different concepts and judicial trends that are coming out. The third, which is important and it was reiterated in a recent decision. When you do a merger, just be very, very careful of 2 or 3 things. One is tenancy rights. You have that old decision of General Radio where the tenancy rights went away. And the other thing, and there are some situations in which we are facing some unpleasant situation in stamp duties. So, for example, UP takes a stand that the stamp duty on a merger is not just on the property there, but on the entire value. So we have a case where the property in UP is, let's say, worth 100 crores. The company is not registered in UP. Okay? But the value of the company which is merging, the value of the merger is say 20,000 crores. So I can't remember, I think it's 3%. So you pay 3% on 20,000 crores or 3% on 100 crores. I would think 100 crores. But UP authorities are taking some very, very odd stand. And the reason why I am saying this is prior to doing all this, what may appear to be a minor issue can become a serious roadblock in the context of actual execution, because as I said, devil lies in the detail. So this is one more experience I thought I should share with you. One more experience which I thought would be useful to you. Can you transfer a business from an amalgamating company out of the amalgamating company between the appointed and the effective date? And the answer is possibly yes, but whether you need approvals, shareholder approvals, how does it happen is another issue. I won't go into details because the idea in this session is not to go into technical details. But the volatility of the world today is leading to a situation that even between the appointed and effective date something changes. Now what do you do with it? Because the entire merger is likely to be approved on the basis that everything will be together in the resulting in the merging. But if it is not, what happens? How will you go to the court? What will you tell them? And so on and so forth. Let me then come to the last 10 minutes so that we have some time for Q&A if you so desire. If you look at the entire issue of restructuring, whether it is external, whether it is internal, I would divide the issues into 4 or 5 baskets. One is tax, second is commercial. Actually, commercial should be the first one. Third is due diligences, financial, let's call it financial. Fourth is regulatory, and in regulatory they have sort of, and fifth of course is valuation. These are the 5 baskets in which I would put it. On the commercial, one of the things I am finding is that many times as professionals we tend to get lost in the tax, company law, etc. But one of the key issues of commercial is what I call governance and perception. So, for example, anything you do, and I particularly have learned this from the perspective of how MNCs look at it, but I think the same thing can apply even to Indian companies. If I do this, first, is it ethically right? But even if it is ethically right, how will it look in the press? Even mid-sized companies with 500 and 1,000 and 2,000 crores market cap are extremely worried because the market in many cases is completely unforgiving and punishing and rightly so. Rightly so. So, does it pass the smell test and how will it be perceived? So, somebody told me a very nice thing. He said, suppose this were to go and get a little better, not better, more prominent press, what will the headline say? I would urge you to consider that when you are involved in a restructuring assignment. Whether it is debt pushed out, whether it is delinking a company, whether it is delinking a unit from a company to do a overseas listing. I am looking at one of those situations and I am asking that question. How will it look if it comes in the economic times 3 months later, right? I am trying to figure that out. Okay? This is commercial. The second is due diligence. I think if you honestly ask me whether it is commercial due diligence, which is to say what is the market demand for this product, how is the raw material prices grow, whether it is financial due diligence, ever so often promoters skip on due diligence partly for time, partly for lack of sort of thinking to its importance, and partly to save our professional fees. And I think there can be nothing more adverse or self-defeating, if I would put it that way, than that, because the implications, I know of a situation where a due diligence was sort of trying to be cracked in 7-8 days, and ultimately 2,000 crores of either non-existent assets or additional liability surface. And the company is still struggling to deal with the aftermath of that situation. So, commercial due diligence valuation. Valuation, of course, is another very tricky, and there is a session by Ketan more on that. But just a couple of points, One is what is happening today with companies having various divisions. The sum of parts valuation is also becoming very important, because this P ratio and all that may not work always. But DCF may also not work always, partly because I have seen, and I don't know if there was some experience, in many cases there is lack of time. There is just no time, because especially listed companies, many times it's kept completely closed because of the worry of matters leaking. And in that desire to keep it closed, valuers are brought in 25 days before, and people like Sujal and Vinkesh will work overnight, like our firms, will work overnight to get valuations done. And many times DCF in a meaningful manner, if the cash flows are not available, we don't have enough time to wait that. And so therefore, we have to do whatever is available in the best possible time and still try and arrive at the best estimate. So you use 3 or 4, you use P, you use comparable multiples, etc. So that's another thing. So sum of parts and what you will do with the constraints of time are the other things. And while Vinkesh will obviously tell you this, in swap ratios, as you know, it's not absolute but relative. Coming to, and I'll come to tax the last. Coming to regulatory, I already talked about stamp duty. The other one is SEBI. In any kind of restructuring, okay, SEBI is obviously extremely important when there are listed companies. Otherwise, there is no relevance. So let me give you an example. A restructuring of holding within the family, let's call it a diluted version of an internal M&A. So transfer of shares of a listed company to a private trust, SEBI has a doubt whether the takeover code is triggered. And I have kept on telling them, what are you talking about here? There is no change in control. So they said, no, but if the trustee is a non-family member, the trustee is a legal ownership. Sure, it's a legal ownership, but beneficiary not so. So on a substance over form test, no, but on a pure form test, yes. So they are not permitting corporate trustees, for example. They are not permitting trustees who are outside relatives, unless of course you trigger the takeover, which you obviously don't want, and so on and so forth. So that's one regulatory example, and they are putting a lot of conditions on even giving this approval or the formal guidance depending on what you go for and what the circumstances go either way. Companies Act, Sujal spoke about NCLT, but the Companies Act has become a major issue in corporate restructuring. And I think the broad point that I want to make is, unfortunately in India, we have entered upon an era of what I call outlier legislation. So you have one guy doing something wrong, so you will try and put so many controls and checks and balances that you are messing up the life of the 95% who want to do business. And I think this is completely against the whole thing of ease of doing business. Of course, we failed to this government, they inherited this government. They didn't frame it themselves. And now what is happening is they are trying to do carve out after carve out out of what is an absurd piece of legislation in the first place, completely outlier. Section 185, Section 186, that is whether, my company, private company, I can't give loans, what are you talking about here? Or overlapping legislation. So you have 222E in the income tax. Why do you need so many things in the company there? Or if you have the companies that don't fit in the income tax act, you can't have so many different pieces of things for the same thing. But so whenever you do a restructuring, keep in mind that the Companies Act is obviously far more stringent, far more restrictive, far more constraining than it ever was. FDI issues, again, for example, FDI and LLP, You have ECB regulations. These are again issues. So FDIs and RBI regulations are also becoming important. That brings me to the last part of what I wanted to speak about, and then maybe if you have any question answers if you want, which is of course tax. The one issue on tax which is of course looming is GAR. Today we are on January 20 and GAR kicks in 2.5 months down the road, unless the budget again of course we have to enforce it, but I don't think it will. Although the GAR detailed guidelines are not yet come. I think just a couple of points I want to make on GAR. You know, one of the things is that people say, okay, there is no GAR today, but I would beg to disagree because we do have a judicial GAR, we do have a legislative GAR. Because if there was no GAR, then what was going on? It was the invocation of a judicial GAR. So we have a GAR for many years, we have a record, right? So we do have GAR, and sometimes I just wonder whether the legislative GAR is actually better than the judicial GAR. I don't remember whether we had a discussion on this once. The reason I say this is because when the definition of what is anti-avoidance, etc., and what is GAR is very high, at the same time it has the provision of the need for the assessing officer to go to the approving panel. The approving panel will have a high court judge. Now visualize this situation that you're sitting in either one today, okay, without legislative GAR. So that tax officer takes out an AK-47 and says, GAR laga dega. Okay, you can do it, you can pass the order, and you can then go on with all the councils and all for the next 30 years, and you know, you will lose that, right? Look at this situation in, let's say, July of 2017. What does the guy at the Bhavan have to do? He has to send you a notice. Then you have to reply. Then the table tells you to go on for 3 months. Then he has to make what I presume will be a 5-page note to send to a high court judge sitting in Delhi, I suppose. I can't remember.